Λοιπόν, πάμε στο δεύτερο μας πάνελ, το οποίο αφορά ένα αρκετά θέμα ταμπού, θα έλεγα, που δεν αγγίζει συχνά η δημόσια συζήτηση, αλλά θεωρούμε ότι είναι σημαντικό να συζητείτε και αφορά την αξιολόγηση των δικαστών. Θα δώσω πρώτα τον λόγο. Καταρχάς να πω, έχουμε μαζί μας τον κύριο Χρήστον Κληρίδη, πρώην πρόεδρο του Παγκυπρίου Δικηγορικού Συλλόγου, ο οποίος έζησε τη μεταρρύθμιση τα τελευταία 3 χρόνια με πάρα πολλές εισηγήσεις και στο συγκεκριμένο θέμα είχε και αρκετό input. Επίσης έχουμε μαζί μας την Τζουλίντα Μπετσίραη από το Bingham Center for the Rule of Law, που έχει εξειδίκευση στα θέματα αξιολόγησης δικαστών, και την ερευνήτρια και δικηγόρο Γιολάντη Μάου. Να ξεκινήσουμε πρώτα με τον κύριο Χρήστον Κληρίδη, ο οποίος θα κάνει μια παρουσίαση. Μετά θα πάρω κάποιες εισαγωγικές τοποθετήσεις από τις άλλες δύο μιλήτριες, κάποιες follow-up questions και μετά συζήτηση. Κύριε Κληρίδη.
I prepared my PowerPoint in English. I didn't know that the language would be in Greek.
No, actually, we'll switch to English because the other two will speak in English.
But since in our panel we have an English-speaking person, out of politeness, I will stick to English. First of all, I would like to tell you a few things about the history of the reform, relating in particular to the mode of appointment of judges in Cyprus. And this, of course, reflects to the quality of the judges that are appointed or promoted. As you probably know, up to 1964, the judges were appointed strictly by the Judicature Council under the Constitution, which consisted of members of the then Supreme Court. Following the events of 1964, under the law of miscellaneous Administration of Justice Miscellaneous Provisions, 1964, lawyers also participated in the Judicature Council. This was contrary to the provisions of the Constitution, but the law was deemed to be constitutional under the law of necessity, in view of the fact that the Constitution could not operate in the absence of Turkish Cypriots, but it had to operate for life to go on, and therefore it was justified under the law of necessity, and it was indeed decided some years thereafter in the Kouris case that it was constitutional to have lawyers in the Judicature Council. Now, the system worked for a few years. Then it was thought that we shouldn't have lawyers in the Judicature Council, and the law was amended again, and it was only judges of the Supreme Court, of the newly established Supreme Court under the Administration of Justice Miscellaneous Provisions law, this new Supreme Court and the new Judicature Council consisted only again of judges. That is, the Supreme Court judges, the 13 Supreme Court judges, which was the latest version of the Supreme Court. So they decided for the first appointments of district court judges, and of course for their promotion to senior president. And then, I have to say, although this is not stipulated in the Constitution or in the law, but as a matter of practice, the administrative president of the District Court of Nicosia was recommended always by the Supreme Court to the president to become a new judge in the Supreme Court. So this was a judicial convention, if you like, which the president followed, that appointments to the Supreme Court would come from the position of the administrative president of the District Court of Nicosia, the position of which, of course, was decided by the Supreme Court. So ultimately, what we had is that appointments to the Supreme Court were basically decided by the Supreme Court. It was only a formality that the president appointed a judge from the district court, because in essence, it was always the president, administrative president of the district court of Nicosia, and for somebody to end up there, it was a decision of previous decisions of the very same Supreme Court. Now, this, of course, created problems. The matter was reviewed because of substantial delays in the administration of justice. And we had, as I had the chance to mention before in the previous sessions, the report of 2016, the Erodogridou report, making recommendations as to how to deal with the delays in justice. Of course, as I have said, Supreme Court was not very quick in responding to the delays. I mentioned, and I quote, the case of Mavronihis versus Cyprus, a commission case. We didn't have a human rights court at the time. At first instance, we had a commission. Decided that Cyprus had violated Article 6 of the Convention as to reasonable time for adjudicating disputes. So since 1996, the courts were aware that there was a problem with delays in justice. And yet they did nothing for 20 years until the Erodogridou report, following which, of course, we had experts from the European Commission, Council of Europe, basically from Ireland, the Institute of Public Administration of Ireland. They reviewed the matter. They came up with a report in March, April 2018, and they all recommended substantial amendments and reform of the judicial system and process. Some of these reforms have been adopted in the latest spate of reforms of July 2022, some not. I don't need to go into the details, but basically the major reform that was recommended was the creation of a new appeals court, which would deal with the bulk of appeals and deal also with the bulk of the backlog. We had, prior to the reform, around 5,000 appeals which had to be heard, they were on the pipeline to be heard. 6 years was the average time to hear an appeal. So the ex-Minister of Justice, Mr. Nicolaou, proposed 3 bills. They were returned back from the House of Representatives as they were found to be inadequate. In July 2020, they were reviewed. In the Bar Council, we set up a special committee that reviewed the whole matter. We made specific recommendations. They were practically all adopted. Now, as far as the appointment of judges is concerned, we recommended, on the basis of the drafts that Mr. Nicolaou produced, that the Judicature Council composes also of advocates and the Attorney General with the right to vote. We quoted, by way of an example, the system in England where you have a commission appointing judges. The majority in the commission are not judges, but lawyers, and the president is not even a judge. This was not accepted by the Supreme Court. We had endless discussions with Mrs. Soula Banaghi at the time, and the majority thought that it would be unconstitutional to have non-judges participating in the process for appointment of judges. So they would have none of it. It was a stalemate which threatened the enactment of the whole reform. And we had to make a concession at the end as a Bar Council, and we accepted the suggestion by the President of the Republic that advocates could participate without the right to vote. And so the Attorney General could also participate without the right to vote for the appointment or promotion of judges. After this concession, of course, the process went ahead and the laws were enacted. In parallel, because of dissatisfaction as far as the appointment of judges to the Supreme Court are concerned, it was suggested that we have an advisory council which would advise the President as to judges that can be appointed to this to the Supreme Court, and of course the Supreme Constitutional Court. Again, there was objection for the participation of lawyers, although not so big objections for the Advisory Council, because the Advisory Council does not participate in the process of appointing the judges. It merely advises the President. So there could be no objections as to the constitutionality of the organ. In any event, the compromise applied also to the Advisory Council. And, of course, the Advisory Council consists of all the judges of the Supreme Court, the new Supreme Court, if it relates to the appointment of judges to the new Supreme Court, and of all the judges of the Supreme Constitutional Court, if the matter relates to the appointment of judges to the Supreme Constitutional Court. The President of the Bar Council, two senior advocates, of 12 years experience upwards also participate, and the Attorney General without the right to vote. We thought about this process and we took into consideration also the report of Grego. The Grego report, which was also instrumental for the reform, especially for the process of appointing judges, recommended that as far as the appointments are concerned, in the appointing body, in order to avoid chronism, members of the judiciary from all strata should participate. In other words, not to have a judicature council consisting only of judges of the Supreme Court for the appointments, but to have representatives from the presidents of the district courts, from the senior presidents of the district courts, from the district judges and from the special courts, or appointing their own representative in the Judicature Council. This was a fundamental recommendation from the Grego report. As Bar Council, we strongly pressed for it, but again, the Supreme Court would not accept it. They thought that it was sufficient if they, that is the Supreme Court, participate in the process of appointment of judges to the new Supreme Court and for the promotions. So this was not accepted. I should also mention that the proposal to adopt the English system was also not accepted. So we ended up with a system where in the Judicature Council, as it sits today, for appointments to the new Supreme Court, is all the existing 9 Supreme Court judges, plus the Attorney General, plus the President of the Cyprus Bar, plus 2 lawyers, the 4 latter without the right to vote, but with full participation. And as far as the appointments to the new Supreme Court, these are made not by the Judicature Council, but by the President. And there we have the Advisory Council, which makes recommendations in 3 times the number of the vacancies each time for the appointments. Now, I will tell you my experience in participating in these two bodies over the past year, since August 2022. The participation of the President of the Bar Council and the two lawyers and the Attorney General, albeit without the right to vote, was very constructive. I should say that as far as the appeal court is concerned, our recommendations were adopted, and for the first time we had two advocates, one from Limassol, one from Nicosia, appointed to the appeals court, which was for the first time that this happened in the history of Cyprus since 1960, for senior advocates to be appointed to senior judicial positions without promotion, first appointment. We also had an appointment from the Office of the Advocate of the Attorney General to the position of the Administrative Division of the Appeal Court. Our recommendation for the appointment of senior advocates to the new Supreme Court, and of course to recommend to the President for appointment to the new Supreme Constitutional Court, were not accepted. It was thought that these positions were reserved, in inverted commas, for senior judges. We hope that in the future this attitude will change. We had, of course, candidates for the position to the Supreme Constitutional Court, which were very well qualified, in my opinion, to be appointed. Nevertheless, we didn't manage that. Also, for appointments to the president of the district courts and the senior district judges, again, although we had candidates from the profession, they were not appointed. It was thought that the process of promotion, if you like, there was fit for the purpose. I think that there is still a long way to go to improve the system. Basically, I think that we need in Cyprus a judges' school, a judges' university, if you like, to which applicants should graduate from. And in any event, if we are not going to have that, we need an independent examination to be given for appointments and or promotion. We don't have that. The system that is applied is basically interviews and qualifications on paper, academic qualifications, practice, and an interview, which is not very thorough, I would say. So there is a lot of improvement. The judges' school that we have now has nothing to do with judges' schools abroad that train advocates, lawyers to be judges. This judges' school is intended only to provide lectures to judges, from judges mainly, to update them with various aspects of the law. It has nothing to do with judges' school, for example, in Greece, from which you have to graduate, and it's a very tough examination that you have to pass. If we're not going to have a judges' school, although it's easy in Cyprus because we can utilize the universities and the law faculties of the universities to train for judges, we don't need to create a separate new judges' school. We can utilize the existing law departments from universities. This is easy. At least we should ask the universities in collaboration with the Supreme Court to make it compulsory to pass an exam for the appointment or for the promotion. I think this is a must. The Venice Commission and the rule of law of the European Union were not completely satisfied with the amendments, although they consider it as substantial progress. and they would like to see further improvements, especially to adopt the recommendations of the Gregor report. In other words, in the Judicature Council to have judges from all levels for the appointment of judges, and not confine it to the judges of the Supreme Court. This in order to avoid chronism. In other words, to avoid the possibility of giving outside the impression that the judges between themselves agree whom to appoint, and it's a bit of a tit for a tat situation. You make my candidate this time, and the next time I will do your own candidate, and so on. So there has to be more transparency. Also, for the Advisory Council, the Venice Commission recommended that candidates are proposed on grounds of merits and not in alphabetical order, as it is today. And if the President would not follow the recommendations of the Advisory Council on merit, the President should give reasons, and of course the decision could be challenged in judicial proceedings. This is the recommendation of the Venice Commission. Of course, this would amend constitutional amendments and a great deal of effort to convince our judges to accept this type of system. All in all, we have certainly an improvement. The system is better than what we had in the past. Still a long way to go. And finally, I will close with the qualifications for the appointment of judges and or promotion. I think the period for first appointment of practicing as an advocate is too short. It has to be bigger. The 6 or so years is not sufficient as far as I am concerned, because mainly young lawyers with only 6 years practice, they don't have tremendous experience in court. They merely go to court to get amendments. Maybe they did an application, summary judgment and things like that. They are not experienced enough to handle cases even up to 100,000. I know that the Ministry of Justice, when the minister was Mr. Nicolaou, obtained the recommendations of experts from abroad to improve the qualifications for the appointment of judges and what is necessary, in other words, for somebody to qualify as a judge. And there are very strict criteria for the appointment of judges, other than the normal that he's of good standing, has no disciplinary, he has experience, and so on and so forth. So I think the system and the quality of justice will substantially improve if we concentrate on the methodology and process of appointing judges at first instance and promotion, and certainly at the Supreme Constitutional Court. One of the arguments I had with members of the Council was that especially the Supreme Constitutional Court, it was not necessary for an advocate, for somebody to be appointed to the court that he had tremendous court experience in cross-examination and blah, 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 blah. Constitutional courts and administrative courts are mainly academic courts. And in other countries, in Germany, for example, they draw from universities, professors, academics, that they know the theory of the Constitution and also of administrative law. So we must get rid of this Anglo-Saxon notion. We have a continental system of administrative and public law, and we have to follow their precedent, if you like, in the appointment of judges. So academics in constitutional and administrative and public law matters from university should qualify for appointment to the court. Thank you for listening to me.
Thank you very much. Mr. Klinides. for this insightful analysis, which actually you experienced personally and you had submitted comments and suggestions. And now that Mr. Cleridis has said the background, I will go to our international expert, Julinda. And since, I mean, the initial idea was to have like shorter parts of the panel. Since Mr. Cleridis had his presentation and Yolandi will also have like a 10-minute presentation, maybe you can tell us, Yolinda, your experience from other countries. I know that you worked with Albania about the system of the evaluation of judges, and if you have anything to comment on the appointment of judges as well.
Yeah, thank you very much. And first of all, huge thanks for the invitation and congratulations for this very interesting and quite concrete and relevant discussion. As you mentioned, so my experience mainly comes from the Albanian system, but I have also been engaged as a CEPEJ expert for some time, so I have also a broader knowledge of what's happening in other European countries, namely Council of Europe, where the EU member states are included as well. Of course, there are different models, and those models in Europe determine why professional evaluations take place, what is evaluated, who makes the evaluation, is it just judges, is it other actors, stakeholders, and how it takes place. It's formal, informal, points, levels of, or grades, etc. And the choice of that model, of course, will depend on the problems or perceived problems that the system has, but it's also a combination between trying to address those problems, but also historical or classic approaches, legal systems, etc. So taking that into account, let me mention that Albania is a candidate country to the European Union and recently embarked on a comprehensive judicial reform where the High Judicial Council was reformed, a stronger role for the School of Magistrates, namely the school where judges and prosecutors are trained before being appointed, like the Greek model that you mentioned. And also the rules for the appointment of the members of the Constitutional Court. And the High Court, the Supreme Court, your Supreme Court, that was previous one, that was initially out of the system. So the system consisted of two levels, so first instance and second instance, appeal instance, and the High Court was outside of the system, judicial system as such, together with the Constitutional Court. Now the High Court has been brought within the system and is under the High Judicial Council, which is a separate independent body. And quite importantly, its composition is half and half. And there was, I'm mentioning this because as a candidate country, there was pressure, or it was suggested by the European Union that Albania follows the standards, what are the best practices in Europe. And one of these best practices, which was also reiterated in the context of the screening of the dialogue, of the first dialogue that Albania had with the Commission, was how do you ensure that on the one side, the High Judicial Council ensures independence of the judges, but at the same time avoids corporativism, what you were mentioning earlier. And this is possible by including in the composition the presence, the representation of other, of representatives of other professions, namely lawyers, but also civil society is included in Albania. So the majority are judges, so it's 11 members, 6 are judges, and 5 are academia, civil society, and 2 lawyers. So 2 lawyers, 2 academia, and 1 civil society representative. And this was considered and was insisted upon as a necessary element in the composition in order to ensure that the judiciary is both transparent and accountable, while at the same time ensuring independence, because the majority is still judges. So a decision can in any case be taken with the votes of the judges. Another element from your presentation is the different rules that apply with regard to constitutional judges at the constitutional level and judges for the Supreme Court. On the composition of the 2 courts, I fully agree with you that depending on the mandate of the court, certain qualities and skills are required. So, for instance, also in the case of Albania, but also in other member states, the people that sit as judges are not necessarily only judges, but also they can apply from academia or from the profession, so lawyers. Of course, in that case, the rules for the evaluation differ, because if there are certain quantitative elements that are being evaluated, you have to measure the number of cases that have been decided by judges, and you have to mention other types, quantitative indicators in the case of academics, etc. But the same happens in Albania for Supreme Court, High Court members. The High Court has a mandate to adjudicate only on not on the substance, but only on principles of the law, and therefore also non-judge candidates can apply to become members of the High Court. As I said, different countries have different rules. It doesn't mean that one system has to be applied to the other. I'm not suggesting the Albanian case as a model. I'm just mentioning some of the solutions that can be employed elsewhere, and also reflecting on some of the important elements that are considered as essential, at least at the European level, for the practices of member states to ensure that the rule of law, that the judiciary is in line with the principles of the rule of law. I can discuss further other elements later.
Just a follow-up question now. I mean, when did the new system of evaluation of judges enter into force in Albania?
So we had previously a High Judicial Council that was composed of judges that were operating as judges, were in office as judges, and this was a side task. Now, after the reform of 2014, of course, the reform of 2014, but then it required laws, and so the reform of the constitution was in 2014. It required implementing laws, etc. The new High Judicial Council, which is an independent body, and it's operating full-time as High Judicial Council, was established in December 2018.
So 5 years.
So the rules, because nothing was there that could be used from the practice of the previous council, the rules were adopted at about 2019 and started being operated from 2019.
Okay, and have you started seeing like improvement in the, let's say, the quality of judges? Were there problems of corruption and now there are not any? What's the, let's say, evaluation in these 3 years?
I have to mention something else, which I didn't mention before, is that at the same time, an ad hoc process of evaluation of judges was introduced, which is called the vetting of judges. It's it happens once, so it's an ad hoc one, and looks at 3 elements. Assets: are judges able to justify the assets that they have? and most of the judges have failed this test, which goes in the direction of what you mentioned about fighting corruption. In terms of numbers, out of 800 assessees, so persons to be evaluated, to be vetted, which included judges, but also prosecutors and high public officials. So for about 400 judges, and the rest prosecutors and high public officials, about 50 have failed the system or left the system on a voluntary basis. Assets, connections with organized crime and dangerous organizations in Albania. And the last was professionalism. But professionalism, in the context of the vetting, is assessed as a minimum, at a minimum. So if you pass that, then you have passed this vetting, and then you are evaluated through these other rules.
In terms of the quality of judgments, or let's say meritocracy, have you?
In terms of the quality of judgments is one of the elements of the criteria of assessing and evaluating a judge. A number of points is given for that purpose. Among the different evaluation criteria, that is the only subjective one, while the others, although being quantitative or qualitative, they are more objective. For instance, are you involved in activities other than judicial activities? For instance, trainings, universities, etc. That's objective. Yeah. While the quality of judgments is very subjective, and it would depend on the. So there is a little bit of.
And last question before going to Yolandi: how were judges convinced to accept this change? Was it a matter of legislation, so it has to pass from the parliament? That's how it happened?
Yes, this was a change in the constitution first, and then in the laws that, of course, came from the parliament. It wasn't an initiative of the judges, and still now judges are, among judges, there is some resistance to, for instance, regular professional evaluations, as it happens in Albania, because the argument is that it interferes with independence. As I said, the counter-argument to that is accountability. So you can have independence, but on how do you make sure that you are accountable about the efficiency of the judgments and the quality of the judgments as well.
Okay, thank you, Julinda, very much. Now turning to Yolandi, who's going to talk to us about judicial analytics and how this area can help in various ways, I guess, including the evaluation of judges. You can start with a, brief presentation or whatever you like.
First of all, thank you, Mr. Kyriakidis, and congratulations for organizing. Also, a big thank you and congratulations to the Procedural Law Unit and the University of Nicosia. So my area of research in the scope of this particular conference is judicial analytics, a topic that is both very new and quite controversial. My research has, broadly speaking, three main aims. So firstly, to acquaint academic and professional circles in Cyprus with the topic, to assess the potential uses of judicial analytics in the scope of judicial evaluations, and to encourage public discourse on the subject. To put my research into the scope of what's already been talked about, judicial analytics in the scope of judicial evaluations speaks to what criteria we use to evaluate judges and how we can make those criteria more objective, fair, and measurable. So whilst we've talked about the composition of the council and the body that decides on appointment, this particular presentation focuses on how we decide and how we can instill more objectivity into the process. Very briefly, I'm going to talk about data analysis and what the point of it is, just to acquaint you. It's the process of collecting information, organizing it, presenting it, modeling it, and ultimately using it to draw conclusions. And the essence is that you can collect massive amounts of information and draw insights from data sets that you wouldn't otherwise be able to draw those conclusions from without the analysis. So data analysis in the legal industry is generally quite a new thing, but it needs to be mentioned that it does not have to do with artificial intelligence. There's often this misconception. Data analysis is the process of using the data we already have to provide insights. So very briefly, it's worth mentioning in terms of development that data analysis in the scope of the legal industry started academically, and it developed into commercial tools, and ultimately now it's making its way into the evaluation of judges. In the next two slides, we have screenshots from modern US commercial analytics tools just to demonstrate the capabilities. So here we can see the name of the judge up there, District Judge Freda Wolfson. And here you can see the different applications they processed and the amount of time it took them. So it helps us visualize different information and draw conclusions from these visualizations. Here we have an analysis of another judge's decisions. So you can see in green, there the motions they granted. The blue represents the motions where there was a partial grant, and then red is the motions denied. So, for example, US lawyers routinely use these tools to make decisions on how to conduct their litigation. They can search the name of a certain judge, and they will immediately know how likely it is that their application will proceed or not. This takes us to the types of data collected and how we can use the data collected to draw insights. So broadly speaking, there are three categories. The two categories of data collected come from the judgment itself. We have readily available data. So that's data like the names of the parties, the name of the judge, the type of case, the value of the case, the types of claimants or defendants. For example, are they individuals? Are they banks? What's their demographic? And then we have data extracted from reading the judgment. So that's information like the key legal questions to be answered, the main legal authorities mentioned in the judgment, the judicial reasoning, and the final outcome. And then, so here's the demonstration. So we have the readily available data that you can pull out immediately without having to read the judgment, and then the information that you can collect by reading the judgment itself. And then the third category concerns contextual information. This is information that's not in the judgment, and it's often unpublished, and that's why it's more worth mentioning. It concerns, for example, the percentage of decisions affirmed by a higher court. Things like the percentage of judgment subject to appeal, the hearing duration, the time taken to deliver judgment, case management behavior, so all kinds of insights about how a judge decides their cases. Now, the important question that follows is what we do with that information. And the main goal of judicial analytics is to create the so-called judicial profiling. And that's basically a report that reveals all kinds of insights and numbers when it comes to how a judge decides their cases. So as we said in the previous slides, you can see their decision-making patterns, how often they find for or against a particular claimant or defendant. You can instill their case management behavior. For example, you can see what percentage of the time they grant a postponement following a request. You can understand their preferences when it comes to the style of advocacy, or whether they prefer, for example, their written submissions to be sent to them electronically, or whether they prefer oral submissions. So collectively, you have this profile, and it gives you all kinds of insights about a judge's behavior. So this takes us to judicial evaluation and how, broadly speaking, judicial profiles and judicial analytics can be used to evaluate judges. And the first question that we should ask is all the data we collect relevant to what makes a good judge? And the answer should be no, because with judicial analytics, you can collect all kinds of information, but not all of it is going to be directly relevant to judicial competence. So, summarizing the global academic literature on the subject, we can divide data collected in three main categories, and we can use a traffic light system to categorize them. So under green, we have all the kinds of information collected that could potentially speak to judicial competence. So these are things like how many continuous learning education hours they spent, the percentage of cases that they've had overturned or approved by a higher court. For example, if a judge has virtually all of their cases overturned by a higher court, that's probably not going to be a very good indicator of their judicial competence. And then you have things like use of the most recent and relevant legal authorities in their judgment. Then we have an orange category. These are data points that could speak to judicial competence or couldn't, depending on how much control the judge has over these factors. There are things like the percentage of postponement requests granted, things like the number of judgments issued per year. And then we have the red category, which is data points that have clearly absolutely nothing to do with judicial competence. And these are things like the public approval rating, so how much the public likes a judge. It doesn't speak to how good the judge is. And also things like the number of dissenting judgments per year. For example, there's no insight to be drawn from a high number of dissenting judgments or a low judgment of dissenting judgments. They're just dissents. So we categorize this information, but selecting what information is relevant to judicial competence isn't always easy. And for that, I invite you to consider the following example. Our relevant data point here is the average duration of hearings. So could we draw an insight concerning judicial competence based on the average duration of a judge's hearings? I could invite our speakers here to provide their opinion, or what do you think? So does the average duration of a judge's hearings speak to how good they are?
Maybe the number of hearings.
Maybe. But we're not sure, right? There's this sense of uncertainty. So presumably not. We can't evaluate judges based on the average duration of their hearings. Why? Because they're likely to be outside of their control. They depend on the court's resources, the availability of courtrooms to conduct the hearings. So all sorts of external factors. However, what if I told you that in a court where everything is equal, resources are equal, the types of cases shared by the judges are equal, the amount of witnesses are equal? What if I told you that in this hypothetical court, 2 out of 5 judges take disproportionately longer to conduct their hearings than the other 3? Can we still assume that the duration of hearings is something completely outside the judge's control? From a data analysis perspective, the answer would be no. It seems from this example that 2 out of 5 judges actually are slightly less efficient in their administration of their courtroom. So the takeaway point here is that some data points that are seemingly completely relevant to how good or bad a judge is can actually provide us with useful insights depending on the context. Now, to put this into the greater image of the greater picture, sort of like what makes a good judge, judicial analytics can have various uses, but the main purpose is to substitute all those subjective and qualitative factors with more quantitative and objective criteria. So we know that generally what makes a good judge can be summarized as follows. You have legal knowledge and analytical skills, you can have impartiality, fairness, clarity of written oral communication, administrative capacity, and efficiency. Out of these 4 factors, with judicial analytics, there's now certain things that we can quantify instead of judging completely subjectively. For example, speaking to impartiality, instead of having a questionnaire and asking people from a scale of 1 to 5, how impartial do you think that judge ABC is? Now with judicial analytics, you can actually quantify that impartiality and see whether the numbers actually show that their decisions are skewed. For example, you can have a percentage breakdown of all their cases that were decided in favor of, let's say, a bank against a claimant. And if the number you get is 95%, that raises question marks. So you can ask, oh, is this judge really impartial, or are they biased towards a certain type of claimant or another? So the idea here is to convert seemingly subjective factors into objective and measurable factors to instill fairness. Now, very quickly, I'm just going to mention what's happening internationally. In the United States, it's a standard practice to use a combination of both qualitative and quantitative measures to evaluate judges. And in Australia, they've only just started to use it. There was recent progress. And there's a recent report from the Australian Law Commission, which basically openly encouraged for the first time the use of analysis and data analysis in the course of judicial evaluations. So they said that the Commonwealth courts should develop a policy on the creation, development, and use of statistical analysis of judicial decision-making, so expressly acknowledging the value of numbers and objectivity. Right, so the key lessons and takeaways from these examples of the US and Australia are twofold. Firstly, that using judicial analytics does really contribute to increasing the objectivity and fairness of judicial evaluations. But secondly, that at the same time, balancing the benefits and the challenges can be quite a difficult exercise. So next, we're going to quickly have an overview over the main benefits and challenges. The use of judicial analytics in judicial evaluations has been proven to lead to more efficient case and budget allocation because it can inform which courts need more budgetary input and which ones don't really. Secondly, it can help us generally observe general trends and use judicial analytics for education and awareness. It's worth mentioning here that US academics actually recommend the use of analytics in an annual lecture for judges to alert them to their potential biases and to just show them, statistically speaking, what are the trends of their decision-making. And finally, we can just use analytics for feedback and professional development. And I think this is quite important because generally we think of judicial evaluations as something that happens merely for the purpose of promotions or retention of judges. But the truth is that we need judicial evaluations to make sure that our judges continuously adhere to the professional standards of their profession. So, for example, through judicial analytics, you could get an insight that a judge uses, albeit not the wrong legal test, a legal test that is not the most recent in a certain type of, in an area of law. So with that, you can just collect the information and develop a sort of like feedback report and help them deliver better judgments. Now, the challenges, firstly, it's identifying inconsistent case law and inconsistent judicial approaches. We all know that the cornerstone of our common law system is that cases with similar facts are decided similarly. But what if basic judicial analysis shows that two judges decide the exact same case very, very differently? That's a point for alert, and such inconsistencies could raise important questions about whether decision-making is indeed impartial, correct, and fair. Now, moving on, another important challenge, and especially in jurisdictions like Cyprus, is the fact that not all information is published. And if not all information is published, if not all judgments are published, it's very difficult to create analytics tools that are actually accurate. Because if you don't get the full scope of a judge's decision-making, then the stats you're going to get are going to be, they're only going to reflect the decisions that are published. So this exercise is twofold: recording more types of information and publishing all case law and all types of information that have been collected. Now, onto human factors. This speaks to the controversiality of data analysis and the use of quantitative factors to evaluate judges. First of all, we have data fatigue. This links to what Mr. Emilianidis mentioned during his introductory speech. He said that if we promote judges based on the number of judgments they deliver, then that can alter their behavior in order for them to beat the numbers and improve their statistics and their performance. So data fatigue speaks to the fact that we shouldn't only use quantitative measures because we can subconsciously influence the behavior of judging in unwanted ways. And then privacy and confidentiality. This is a big one because especially in Australia, where there was resistance about judicial analytics, many judges objected to their data being collected and published. There's a particularly interesting incident where an academic institution published a report that said that 40 out of 70 federal circuit judges took more than a year to deliver their judgments, and they expressly named those judges in the report. And there was a very negative reaction from the judiciary because they didn't want the names of the judges to be mentioned, and they didn't want them to receive that kind of negative criticism. So the solution of the American Bar Association for this is that if we are to deliver objective reports based on data, the results should not be disseminated in a format that would readily allow the public or the media to compare or rank individual judges for obvious reasons. And now let's look at the potential of judicial analytics in help us eliminate bias. This is one of the greatest motivators for many legal systems to adopt judicial analysis into their judicial evaluations, because by observing absurd trends in statistics, you can potentially use those numbers to inform you as to whether to launch an inquiry or not. So what if I told you, for example, that Judge A in refugee applications tends to disproportionately reject them compared to a variety of other judges? What if the rejection rate, the average rejection rate of the court is 0.6%, and then that particular judge's rejection rate is 23%? A possible explanation could simply be that it just happens that the cases that that judge got call for a dismissal, correct? But generally speaking, such a great difference in numbers could speak to some sort of bias. So the idea here is to use data as a flag rather than a punishment, and whenever there's a great inconsistency that could speak to bias, launch a further inquiry to identify whether that judge is indeed biased. This was very well put by the president of the Australian Law Commission, who said that yes, data could potentially be useful in relation to bias and unconscious bias, but that might only be enough to raise a question, not to punish them and not to assume that they're biased. So all he said is that it's probably enough to use data to help you alert to potential incidents of bias, and then ask the judge themselves, I quote, have you reflected deeply enough on your own biases before you have made your decision in these cases? Now, let's look at an example that demonstrates the difficulties of using data. So let's say that we have Judge A and Judge B, and we're only deciding who to promote based on numbers. For some reason, they're a bit skewed, but I'm going to take you through them. Let's say that Judge A has a lot less of their decisions overturned by an appeal compared to Judge B. Judge A takes a lot less compared to Judge B to deliver their judgment. 23% of the cases of Judge A actually go to trial. So a large number of them are either settled or discontinued compared to Judge B. And then finally, the average number of sources cited by Judge A is a lot more compared to Judge B. So based on these numbers alone, the question is, what can we say about the two judges' competence? Which judge could arguably be more competent? What would you say? Maybe Mr. Kyriakidis?
Between Judge A and B?
Yeah, purely on the numbers.
I would say A.
Yeah, correct. I mean, it seems obvious. Judges A's metrics are better in every respect compared to Judge B. What if, however, I told you that Judge A, their decisions are extremely long and difficult to follow compared to Judge B, who issues very clear, concise, and easy to follow decisions? What if I told you that many of the sources cited in the judgments of Judge A are outdated or not really relevant? And what if I tell you that the rationale of their decisions cannot be identified easily compared to Judge B? Would we still have the same answer? And I presume that it wouldn't be a clear choice of Judge A anymore, because now we have context into their numbers. Mm-hmm. So this example seeks to demonstrate some of the difficulties of using only data without any context to evaluate judicial performance. Right, so to wrap up, we are currently collectively using methods that are generally subjective, and through using judicial analytics, we can actually turn some of these subjective factors of impartiality or competence into more objective and measurable factors that can make the whole process of evaluating judges more fair. And this is to emphasize the conclusions of the Australian Law Commission report I mentioned. They said that, to be clear, the recommendation is for courts to explore developing such policies of collecting and reporting numbers, and that the Australian Law Commission was careful not to dictate that data collection must occur or that the data should be used in particular ways. And this is to show some of the reservations that still exist when it comes to using statistics. So that's my input.
It was amazing. Thank you so much. It was really, well prepared, and we're looking forward to your paper. I hope you go on and publish it, and maybe I'm going to ask a follow-up question, Mr. Kliridis, and then we can take a few questions from the audience if there are. Do you think you experienced judges both as a lawyer and as a president of the Bar Association. You were in negotiations with them during the reform. Do you think that there will come a point soon that judges will accept going to a model which is, based on KPIs or judicial analytics for, their evaluation?
I think for the time being, no. As has been mentioned, in Cyprus we don't have a sufficient database anyway for this system to work. This judicial analytics, I understand, requires a very sound data collection basis in order to be useful and helpful. What happens nowadays, in my experience, is that advocates who want to apply for the job or for the promotion, especially for the promotion, they have to send judgments they have issued. But these are judged on the basis of the experience of the judges, the members of the Supreme Court, not in a scientific, analytical manner. So I think for Cyprus it sounds a bit like science fiction for the time being, although I can see the use of it. It doesn't mean that we have to reject this. We have to start building on it, rather. And we have to start making a more accurate basis, statistical basis, in order to be helpful. Of course, I can never think of a situation where the process will be simply mechanical. You put into the computer these statistics and like a sausage making, and at the end you get the sausage. You put the meat and you get the sausage. No, I think still the interview plays a crucial role to speak to the candidate, and also the knowledge of the candidate is very important. The statistics will help. In my experience, with my participation in the transitory councils, judicature councils, is that there is a tendency nowadays to improve the situation in the sense that seniority is not always the most crucial factor. In the past, as you know, seniority was very important, very crucial. In the promotions to the position from senior district judge to president, and or from president to the Supreme Court. The seniority was not followed 100%. There were exceptions, and there were, of course, complaints about this from judges, I mean. I recall in one case when we have to decide between two candidates, that it was unanimous within the decision within the council that the judgments of Judge A were much better than the judgments of Judge B. So they're taken into consideration, but not in a scientific manner, rather in an empirical, I would say, manner. This is how it works today. But, of course, things are moving fast, so we have to start preparing for this. So this paper will help us, at least at the beginning, to start accumulating the necessary data to be able in the future to use this methodology.
Yes, I fully agree. And something that Yolandi was telling me is that there is a tool that you insert the judgments and then you get the statistics, but it only works with English judgments. So if we're going to utilize such solutions, we need to start translating our judgments.
May I make a number of points?
Yeah. And then Alan wants to say something.
I also...
So it is very true that right now, given the administrative capacity of the Supreme Court as the body who's responsible for the promotion of judges, it's actually impossible to adopt any scientific method of evaluating the judges. And this is exactly why the process of evaluating judges is actually going to be greatly advanced by having an independent body that's responsible for court administration. Yes. Because if we have such a body, it's that body that's going to be able to collect the time and expertise that's necessary to collect all of the numbers that are ultimately going to be needed to evaluate judges. Another interesting point, you mentioned that the committee read the judgments of two judges and they uniformly decided that the judgments of Judge A versus Judge B were better. In that respect, there's actually a really interesting point made by a US white paper. Basically, they explained that in certain US states, instead of sitting around the table and reading the judgments and deciding which judgments are better, they have a sort of questionnaire with different elements of what makes a good judgment. For example, clarity, organization, variety of legal sources. And they give this questionnaire to both lawyers and non-lawyers, so the public, and they have them evaluate the judgment on a point system. So the idea there is to instill some objectivity, but also to have the input of the public.
Yes, okay. I think this gives me an idea with the court service that we were discussing, you were discussing rather in the first morning session. Within the new court service that we will set up, perhaps we should have a department on statistics, on court statistics, to be manned by proper officers and trained personnel. So we would need that as part of the new court service, if we are moving forward anyway.
Yeah.
On this last point, there was a question earlier from the audience saying and pointing out the differences between practices in courts. So, for instance, just to give an example, one of the criteria for evaluation of judges in Albania is the length of proceedings. It's the actual length, it's not the disposition time, which is the indicator used by CEPEJ, which is basically, it's not a direct indicator, like when the case started, when it finishes. It's the average length, so it measures the exact length of proceedings and then measures the average. It was very difficult to get that from for the judge, who maybe had part of his office in one court and then another part in another court for the evaluation period, because the practices of recording that in different courts were different. And that's what one of the persons from the audience mentioned this morning. Mm-hmm. So before this effort of building the analytics, there is another effort of uniformization of the data that is collected from the different courts and stages. In terms of seniority, I wanted to echo that point. There was a discussion inside the High Judicial Council in Albania on where to put seniority in the context of professional evaluation, because it was mentioned in the law. So the idea was, after you have evaluated different elements such as the quality of the reasoning, so both qualitative elements, the quality of the reasoning, the complexity of the cases, how much do you refer to EU or Council of Europe, or European Court of Human Rights judgments, etc., and quantitative elements, so the number of cases, average duration, number of hearings, etc. Once you've done that, what else do you evaluate before going to seniority? Let's say once you've done that, both candidates are very good. When does seniority come as an element? Do you go to other elements before that? Let's say participation as a lecturer or participation in other activities, engagement in bodies, representative organizations, etc. Or do you immediately go to seniority? And does seniority have a part on that? And there was, of course, a push for considering seniority, but the advice from the project that was a European assistance project was to push that towards the end. So if all other things being equal, then you consider seniority. My last point is about the use of some criteria that you mentioned in your presentation, namely the appeal rate and the reversibility of judgments. So in civil law traditions, jurisdictions, there is a tendency to reject those criteria because they would interfere with the independence of the judges. So the judge has independence in deciding a case according, of course, to the rules, and but should not be decided on the basis of how those decisions or to what extent they would please the higher interest. So it is considered strongly considered as not to be included in France and Germany, in Italy as well. And in Albania, in the light of that, it was included before as one of the criteria, and it was removed from the law later.
May I add on that, on 2 points? Firstly, on seniority. So from the US white paper I mentioned previously, it's interesting to see the different perspectives. In the US, they use seniority as a benchmark, so a qualifying benchmark. And once you have the minimum number of years of experience required, then they forget about seniority and they look at all the other factors. So seniority as the first step, and then other factors taking a precedent. Correct.
Criteria, right?
And then when it comes to the reversal rate, it's also very interesting to observe the differences between common law systems and civil law systems. It appears to be an interesting feature when it comes to common law systems because actually the reversal percentage is considered a very important factor. If as a lower court judge you have, let's say, 80% of the judgments that you delivered and were appealed reversed, it means that ultimately most of your judgments were deemed somehow inadequate from the superior court standard. So they really prioritize that. So it's very interesting to observe the differences.
Thank you. Alan?
I would like to make 2 points. First is about the experience that we have in Croatia, where also the framework criteria for the evaluation of judges are perhaps the most controversial legal document nationwide with judicial politics is considered. Our framework criteria are used not only in the promotion, but also in the periodic evaluation, and they contain mainly the productivity criteria, meaning how many cases should the judge produce each year. When it comes to the promotion and the evaluation on the basis of the quantitative factors, this is one of the elements, which is then combined also with the reversal rate, and the reversal rate is a point where I would agree. From the perspective of independence, it can also have some negative impact. But in the end, the outcome of the application was, since the framework criteria were always changing, the appointments of judges by the High Judicial Council, composed of the majority of judges, was in a sense paradoxical. On one hand side, it seemed that judges who had most simple cases had the highest productivity and had the highest chance to be promoted. On the other hand side, the judges were also fixing their productivity rates, like, for instance, temporarily closing a number of files at the end of the year and then reopening them in order to kind of achieve their productivity criteria. And also, finally, in the discussions within the High Judicial Council, where you came up to a ranking which could then be changed by the members of the High Judicial Council on the basis of an interview. And no matter that the High Judicial Council argued that, well, you cannot apply only quantitative criteria, in the end, the public mainly had an impression that the selected candidates were just by chance the children of judges. So the element of the cronyism, at least in public perception, were still maintained. So one of the crucial questions is how to actually frame the judicial analytics and how to make it unbiased, and I don't know whether and how we can achieve that goal. But the second point, just to point that your presentation, wonderful presentation on judicial analytics, is a very American one. Well, in Europe, you have a very high level of reluctance in publishing any sort of judicial analytics. So I would just like to ask you whether you know about March 2019 law in France, which has expressly prohibited judicial analytics and made it a criminal offense, punishable by up to 5 years in prison. Textually, it is a criminal offense to evaluate, analyze, compare, or predict the behavior of individual judges, which, well, leads me to a question. Should we not, or should we take a look at the collection of data about performance of justice as an element of constitutional standards of publicity? Should the transparency of judges, justice also entail transparency of judicial behavior? And, well, what do you see as a possible remedial factor here? Thank you.
First of all, I would like to thank you for that question. That was actually a slide in my presentation that I skipped for the sake of time.
We can see it if you
let me see if I can try again and go back.
Yeah, because I told you to hurry up, that's why you skipped.
It doesn't go, yeah, I don't know. But anyway, the slide just has a quote of the...
There it is.
Oh, perfect. Okay. So, 1 second. Nope, it's further down. Shortly. Okay, I think here. Right, so, yes, this is an amazing opportunity to talk about the French ban, which is considered extremely controversial. So to give the audience a little bit of context, the French ban was triggered by a report that compared the decisions between different judges when it comes to asylum cases. And what the report basically revealed is that some judges had disproportionately larger rejection rates when it came to asylum cases compared to other judges. So the report made the point that from a statistical perspective, the differences were significant, and that it's generally unlikely that those discrepancies were random, and it's more likely that they were attributed to external factors like potentially bias. Now, as a response to that, the judicial body reacted, and there was an amendment of one of the laws, and basically the ban says, I quote, "The identity data of magistrates and members of the judiciary cannot be reused with the purpose or effect of evaluating, analyzing, comparing, or predicting their actual or alleged professional practices." Now, a number of points to be made about this. First of all, some critics thought that the law means that you just can't name the judges explicitly because you're exposing them and you're affecting their impartiality. Some other critics questioned the fact that the data is already out there. So it seems that what the French legislature did was to ban the process of analyzing the data and drawing conclusions. And it seems unclear from the law whether the ban only concerns using data analytics tools to do it, so doing it automatically or doing it manually. Insofar as the law means that you cannot manually review judgments to draw such statistical insights, it arguably seems like a bit of an extreme measure, and this is the view of many critics that are advocating for freedom of speech and freedom of information. To give you an example of what this ban could mean from a Cypriot constitutional perspective, it would be legal in Cyprus to publish a report that records the number of dissents made by each Supreme Court justice per year. That would amount to using the identity data of judges to evaluate and analyze and compare their performance. So it's a very controversial law. I'm very glad you mentioned it. Most jurisdictions seem to advocate for a balanced approach that seeks to strike a balance between the public's right to access information and then protecting judicial identities and independence and not exposing them clearly with their names to the public.
Excellent, thank you. Any other comments, suggestions? Okay, I would like to thank Mr. Kliridis, Yulinda, Yolandi for the excellent presentations. It's time for lunch. You're all welcome next door, and we'll be back at 2:30. We have a presentation of the survey we ran with IMR, and then a last panel. So thanks everyone. So we're back after a lunch break, and we now welcome Christina Kokalu from IMR, our colleague and supporter and very important partner every year. And what we're trying to do is to create an index, some indices basically, so that every year we measure some indices and see whether there has been progress or deterioration in the area of the administration of justice. So Christina is here to present us this year's results. And Christina, the floor is yours. Μπορείς να μιλήσεις ελληνικά ή πώς προτιμάς?
Ελληνικά να μιλήσω. Δεν το βλέπουν πίσω όμως.